Hey, good afternoon, everyone. Sorry. It's a great honor and a great pleasure to introduce Alexander Destriou to you. He is one of Europe's leading scholars of digital regulation. He's known for his influential work at the intersection of competition sectoral regulation and platform governance. Alexander directs the digital research program at the Center on Regulation in Europe, and he is professor of European law at the University of Namur with lots of visiting roles amongst other institutions, the College of Europe, Sciences Po, and so forth. He has been closely involved in the policy debates surrounding the European Union's Digital Markets Act and the Digital Services Act, both as an academic analyst and as an advisor to European institutions and regulators. His work, which I greatly admire, offers a framework for understanding how these new regimes shape the power of big tech. He draws on traditions of public utilities and common carrier regulations while remaining attentive to innovation and fundamental rights. So today he will speak to us about his latest research on EU big tech laws as an emerging form of public utilities regulation. And we are really thrilled and delighted to welcome him to share his insights and reflections with us. Let's give Alexander a warm welcome.
Okay, so thank you very much for this kind introduction and for this invitation. It's pleasure to be here. I was in Hong Kong 2 years ago, and I also was in Shenzhen, and I was extremely impressed by the technological progress of this region. And so it's always a pleasure for me to come back because thank you very much to see, I mean, how technology is progressing, and sometimes here that you see that the fastest way. As you know, what is said, Europe is good at regulating, others are good at innovating, but I think also I was interested to, I mean, I think the law that I will talk to you about have had some interest also outside of Europe. And sorry, thank you. And therefore, I think it's interesting to discuss where we are now with those laws. So basically, I wanted to discuss those EU big tech law, and in particular the Digital Markets Act and the Digital Services Act, which are part of the EU digital rulebook that has been adopted some years ago now in the European Union, and which have 2 years of implementation, we can say. And I wanted to ask this question, which was in fact a question which was asked to me by a number of American US antitrust scholar. And yeah, thank you. Thank you very much. Whether this is public utilities regulation. I mean, we know what is public utilities. It's telecom, it's water, it's electricity. And the big question is whether we can consider that those digital platforms are, providing the new form of, or the 21st century's form of public utilities. And if they are, whether we should regulate them as public utilities, and if we should, whether we can consider what we have done in Europe as a form of public utility regulation. Okay, so that's a little bit the question of the paper. So I will present here the main thrust of the paper, but you can find the paper on SSRN. And what I will try to show you today is that even if it was not thought as a public utility regulation, this is very clear. I think no one in the European Parliament, in the European Commission, or very few people, like I would say, in the European Parliament, the Commission, or the Council of Ministers, thought that they were regulating public utilities, or they were regulating as a public utilities. But I would say that we could read what has been done as a form, as an emerging form of public utility regulation. And maybe, and we're discussing that over lunch, the main transformation of those EU big tech law is that they have now present the platform as a new form of public utilities. Okay, So I told you this is a question which was asked by American lawyers, because there is this famous case that one of the case of the Supreme Court, where Justice Thomas, in a concurring opinion of the case, was mentioning that we could consider digital platform as a form of public utilities or as a form of common carrier, which is the old common law doctrine, British doctrine of, if you are a carrier, you have to offer your services to everyone in a non-discriminatory manner, And the common carrier doctrine, which is a very old, nearly a middle-aged doctrine, when then was transformed, I will come back to that in a minute, in the public utility regulation. And, this case is interesting because it's a case about the deplatforming of Donald Trump just after, at the end of his first mandate, after the January 6th event, where, as you may remember, he has been deplatformed from what was called Twitter, so X now. And so that led to a series of legal action. And one of the questions was whether X now is a form of public utilities or common carrier which should offer its services to everyone, including to Donald Trump after the January 6th event. And, the Supreme Court did not consider that X is a common carrier, but went on the free speech argument. But what is interesting is that Justice Thomas considered that they could be considered as a common carrier, and that concurring opinion led to a series of doctrinal papers in the US, more I would say that in the EU, on whether those platforms are public utility. Okay. So, but first, before going to that question of public utilities, I just want to be sure that we are on the same line of what the Digital Market Act and what the Digital Services Act are. So basically, this is a very summarized view of the DMA, and I know that some of you are much more expert on that, but just to be sure that there is a kind of a level playing field, if you want here, I would say that the Digital Market Act, which has been adopted so in 2022, is a form of the anti-matrix law. I mean, I don't know for those who have seen that movie Matrix, but the thing is, Matrix, you end up to be in one ecosystem. You are in a way prison of that ecosystem, and you don't even know that you are part of the matrix. Only few people know that they are part of the matrix and want to escape of that matrix. And basically, I think the goal of the DMA is to alleviate that we finish in just one ecosystem without necessarily knowing it. So the goal of the main goal of the DMA is to diffuse power, okay? To diffuse ecosystem power. Now, if you read the objective of the law, it will mention market contestability, which is, be sure that the barrier to entry are not too high, and it mentioned fairness. Now, the problem with fairness is that everyone could agree with what fairness is, but everyone has its different conception of what fairness is. And there is more and more now in the title of European law, the title fair or fairness, but it may mean different things. I would say, and we can discuss that, this is mostly about distributional fairness. So basically that the added value which are created by the platform could be distributed in a better way, in a more fair way. While market contestability, if you want, is a form of ex-ante fairness, okay, or a form of equality of chance. So it's also a form of fairness, contestability, but contestability is an ex-ante fairness, and the other fairness of the DMA is more an ex-post fairness. Now, the main power, I would say, that the DMA is trying to regulate is the systemic gatekeeper power. So it's one platform. You need to go to that platform if you want to reach the European user. So hence this idea of gatekeeper power or gatekeeping power. And to identify those gatekeeper which are regulated, the DMA foreseen 10 digital services which are called core platform services. That's the terminology that is used in the law. And basically those are 10 digital services which have been selected by the legislature because the market has tipped in the favor of one or two main companies. Okay, so those were where the market has tipped, and this is why. And again, we were discussing that over lunch. The AI is not into it as such, because back then the AI services, the LLM, the AI agent, whatever, has not been tipped in favor of one company. Okay, but so you find, I will not go to all of them, but you find cloud, operating system, virtual assistant, web browser, search engine, a number of specific app like search engine or social network. And so for the company which are providing one or several of those digital services and which have gatekeeper power, and the gatekeeper power is mostly defined with a size criteria. So you have to have a certain more than 70.5 billion turnover in Europe, or you have to, you have to connect with 10% of the EU population, then you are supposed to have a gatekeeper power. Okay, and so the company which have been identified are the usual suspect, you know, Google, Meta, Apple, so mostly US big tech, but there are there are TikTok, so one Chinese tech, and Booking.com. Okay, now the goal of and therefore the obligation of the DMA is related to reducing entry barriers, to facilitate the entry. And so, and I think that's very important because, you know, very often now the people tend to oppose regulation with innovation, which I think if you say that at that general level, it's wrong. You know, it's true, some regulation may decrease or reduce innovation, but some may promote innovation. Okay, so to say that regulation is always bad for innovation is, I would say, a wrong statement because it's too general. And if you look, for instance, at the work of Philippe Aghion, you know, who get the Nobel Prize for Economics last year, and who is a big scholar, an important specialist of innovation theory, he will tell you that the DMA is a very good law, you know, because it reduces entry barriers and it promotes, therefore, innovation for a small innovator, being in the US, being in China, being in Hong Kong, being in Europe. So it's not as it is sometimes depicted by the Trump administration, an anti-US law, because, you know, and in fact, most of the beneficiaries, I would say, of the DMA are American firms, like, for instance, the Go or others. So we could, or Epic. So we could not say that it's neither an anti-innovation law nor an anti-US law. It's a law which is promoting innovation wherever they are coming from. Now, to do that, there are a number of obligations. There are a list of more than 20 obligations. I will not go to the detail of this, but just to understand the logic of those obligations, some obligation or prohibition are preventing anti-competitive leverage. So alleviating, for instance, that you are tying one product with another in your ecosystem, like, for instance, Google has done with Android and Google Search, by facilitating user switching or multi-homing from one platform to another. So, for instance, that is why you have a number of data portability obligation. If you want to move from one social network to another, it should be easier to port your data from the new social network. To facilitate business entry with a number of access and interoperability. So, for instance, there is, if you developed a new wearable, you know, like a ring or like a watch, you now it's easier for you to connect, for instance, with the Apple ecosystem than it was before, because the idea is that it should not be only the Apple Watch, which are interoperable very well with the Apple ecosystem. It should be any other smart watches, and then some specific obligation for online transparency. So basically, you know, and I will move to the next law. Here, really, the role is to diffuse economic power. Okay. Now, the other law, the Digital Services Act, which has been adopted at the same time, has a very different objective. You know, here, the law is to govern economic power and to try to change the the internal governance of the firm, you know, to be sure that they that their service has less risk for the society. So basically, you know, the DMA is to try to diffuse the power and to be sure that the market will incentivize better behavior by the firm, while the DSA is mostly about the internal governance of the firm and to try to be sure that internally they will operate better for the society. So basically, the main objective of the law are to the DSA to reduce illegal and harmful content on internet, okay, and to mitigate the systemic risk that a digital service, and in particular a social network, can pose for the liberal democracies. Okay, and we have seen in the US after those January 6th event, in Brazil and in many other countries, that by manipulating the social network, you may pose a threat to liberal democracy. No, I don't buy this argument that only the social network create the far right or the far left in Europe. I don't think it's much more complicated than that, okay? But I would say that it may contribute to it. So basically, how it works here, the platform which are regulated, we have it's mostly social network and marketplace, mostly US and European social network and marketplace from the US and from China. Basically, they are called very large online platform when they have more than 10% of the EU population which are connected to them, which means 45 million users. And if they are, if they meet the threshold, they have what the law would don't call like that, but what I call is as a systemic influence power. And therefore, because of their systemic influence power, they need to be regulated. Okay. And basically, what are the regulations is that they have more due diligence obligation, better content moderation. They have to do, and that's really interesting in terms of also understanding better the black box of those algorithms, to do an annual systemic risk assessment and then to take mitigation measure. And then there is a number of enhanced consumer protection and consumer empowerment measure, for instance, prohibition of dark pattern, more online ad transparency, and there are some specific provision for minor protection. Okay, but so here really, and I insist on that, the role is not to create more competition on the market. The role is to ensure a better internal governance of the platform. Okay, so those are the two laws that have been adopted so far. And now the big question is, do they deliver? And then I would say that maybe they have been a bit oversold by the Commission when they have been adopted, because, the main goal, if you think about it, the main goal of the DMA and the DSA is to regain the early promises of the internet. You remember, if you read internet libertarians of the 90s, like, for instance, John Perry Barlow, who had this fantastic declaration on the independence of the cyberspace of 96, Barlow was promising a kind of a better world, and he said very explicitly, we will have a better social contract than what the member states have done. Now, 30 years down the road, we could see that indeed internet has been a liberating tool for some, but is also a tool which has allowed some company to, monopolize or to centralize the intermediation. So I don't like when we say that internet is a disintermediation tool, because I think it has led to a global intermediation instead of a local intermediation. But the intermediation has not disappeared. If you want to be a seller on e-commerce, I think you have to go through Amazon, through Temu, through eBay, or whatever. Okay, and so basically, those laws are trying to regain the promises of the early promises of the internet, which is more decentralization, more empowerment, and you don't do that in 2 years. So clearly, we only see some timid change at this stage, 2 years down the road. But I think those are important because they set up, compass, a direction where you want to go, more decentralization and more and better internal governance to decrease the risk. Okay. Now let's go to understand and that's the core of my paper, whether those two laws could be seen as public utility regulation. Now, the concept of public utility regulation comes from US law. And in particular, I would say it's a continuation of the common carrier doctrine, but which has been really on steroid, if I can say, with the New Deal in the US. So 100 years ago, with the development of the New Deal, where there was a lot of new regulation, regulatory push under FDR, which led to a number of new agencies in the US, like the Federal Communication Commission, the Federal Trade Commission, and so on, and which was, the birth of the regulation as we know it and the public utilities. But the thing is that if you look at the US scholarship, I mean, the concept of public utilities is different according to different authors. And what I have tried to do in this paper is to try to systematize that a little bit, because when I was reading all those papers, I was a little bit lost, to be honest. And so I would say that there are first two main distinctions between a broad view, which was very much pushed by Justice Brandeis when he was at the Supreme Court. And basically, he would identify every essential societal infrastructure as a public utility, that should be subject to public utility regulation, okay? And there is, like in antitrust, there is a kind of neo-Brandeisian view of public utilities, which is developed by some scholars in the US, and in particular at the Vanderbilt Law School, where they want to connect back to that kind of a Brandeisian tradition of a broad view of what is a public utilities, because you have then a much narrower view, which has been pushed by a number of economists, and for instance, at Chicago and others, which were saying public utilities is only when you have a natural monopoly or possibly a natural oligopoly. But you see that, you may have some essential societal infrastructure which are not natural monopoly, okay? And so they would be considered as public utilities if you take the broad Brandeisian view. They would not if you take the more economic approach, if you want. So I think it's important to have that first distinction. The second distinction, which make the concept difficult also, is that the way those public, so the first is about what is a public utilities, and then the second distinction is how you regulate public utilities. And then there has been also a change, and that's an evolutionary change in the US law. Because, at the beginning, at the time of FDR and at the time of the New Deal, we were in what I could say an old static paradigm. The role of the regulator was to replicate the competitive market outcome. So if you were the electricity regulator, for instance, or if you were the telecom regulator in the US, you didn't want to push for more competition in the field. You just want to price regulate, to regulate the retail price, and said, if the market was competitive, the market would be, the price would be equal to the cost, and therefore I will impose a cost price regulation on the electricity provider or on the telecom provider, okay? That was the old static way of doing a thing. Now, what is interesting is that after the Ronald Reagan arrived, and then after the Reagan Revolution, I would say, there has been a change in the way you regulate public utilities in a much more dynamic, and here the idea is to promote competition. So to try to reduce entry barrier as much as you can to have more competition. It starts with the airline industries, in the 70s, so a little bit even before Reagan, and then it went on telecom, on energies, and so on, okay? And so the paradigm is very different because you try to dynamize as much as possible the market by reducing entry barriers, and you hope that by creating a number of access obligation, wholesale access obligation, you will have more new players coming in the market, and therefore the market could regulate instead of an authority. Okay. Now that has been a change that you've seen, and has been very well described in several U.S. antitrust paper that I quote in my paper. But this is a revolution, let's say, which took place in the 70s and the 80s. Now, in the European Union, when we start to regulate the public utilities, so energy, telecom, and so on, we directly, because we did it much later, we did it in the 80s and in the 90s, we directly went with a dynamic paradigm, you know, so with a paradigm which aims to decrease entry barriers. Now, what does it mean, those two views for the public utility regulation, you know? And here, what I have tried to do is to try to look at the, I would say, the 4 layers of what is a public utility regulation. And I have tried to compare and contrast the old static paradigm on the one hand, and then the more dynamic one on the others, okay? And if you take the regulation of market structure, so who can provide the service, you know? Here, I would say that in the old paradigm, you were really creating a lot of entry barriers, legal entry barriers. So basically, you know, there was a legal monopoly in many countries in the European Union, for instance, until the liberalization, you had only one telecom players or one electricity players, and you could not have another one, okay? So that was a legal monopoly. While in the new paradigm, it was completely different. In the new paradigm, you reduce entry barriers, and so you try to stimulate competition. If you now look at the second layer, which is the access regulation or the common carrier, okay? In the old paradigm, as I was telling you, the main regulation was at the retail level, so on the relationship between the provider of public utilities and the end user, and it was a retail access or a retail price control. So everyone had the right to have an electricity connection at a price which was affordable and at a price which was cost-based, okay? And the concept of common carrier was to say that the electricity provider or the telecom provider should offer its service, should provide its services to everyone in the country, you know, without any distinction. They could not say no to you because you were too far or because you were too poor, okay? So there was some exception in terms of service integrity or security, and some of those exceptions are already in the common carrier doctrine, but it was quite limited. Now, in the new paradigm, that is very different because there, you know, what you want to say is that you don't regulate the retail access and the retail price, but what you do is you regulate the wholesale access, so the relationship between firms. Because let's suppose that you are a new telecom player in a country, okay? Of course, you don't have the network, and you cannot build your network from scratch. You can take a very good example in France is this operator Free, who is a kind of a maverick in telecom, you know, but Free, and it's very cheap in France. Free at the beginning, you know, didn't have any network. So how Free could offer its services by renting the network of the incumbent, Orange, in France, the old France Telecom, you know. But of course, Orange didn't want to rent their network to Free because they would say, yes, but then I'm creating a competitor to me, so I don't want that. And so what the regulator, the French regulator did, it imposed to Orange to rent its line to Free at a cost-based price. So you see that you still have an access regulation. The access regulation now is at the wholesale level, not at the retail level. Then the third layer of the public utilities is universal service. So universal service means, or public service, means that everyone can get access to the service at a price which is affordable. Because those services are so essential. Remember, they are public utilities. Those services are so essential that we want to be sure that everyone in the country have access to it. Now, if we're in the old paradigm, because you have only one operator for the whole country, this operator could do what we call cross-subsidization. So they were making a lot of profit in the cities, which were very dense, and so the price there were above their cost. And then they were that extra profit that they were making in the densely populated area could cross-subsidize the loss they were making in the countryside, where of course there, well, of course in Hong Kong you don't have everything is dense. So, but I mean, if you can imagine China or France or the UK or America, there are some zones which are completely with very few people, and there, of course, a telecom line per customer cost much more. And so you had a cross-subsidization between the densely populated area and the less densely populated area. That was possible because you had a legal monopoly. It was the same operator providing both. Now, if you liberalize, what happens is that the price can go down in the cities, and therefore this cross-subsidization is not possible anymore. And therefore, what you have to create is a specific universal service fund to fund the losses that the universal service provider were making in the less densely populated area. Okay, and then the last layer is risk and risk prevention, because those public utilities being so essential, you have to be sure that they continue to function all the time, and you have to be sure that the consumer are particularly protected there because it's so essential services. So, you have a number of individual risks that require an enhanced consumer protection, and a number of collective risks that require a number of obligations requiring continuity, for instance, of the service, security, and resilience. Okay? So basically, that's how I see the public utilities, or the 4 layers of public utility regulation, and how they have been changed from the static framework of the 30s to the more dynamic framework that we have now in many countries in the world. And so the last question is, yes, but what about the DMA and the DSA in that? And can we consider that as public utility regulation? And my answer is yes, to some extent. Okay, and let me take back again the 4 layers of the public utility regulation and the dynamic too, because my point in the paper is to say that it's an emerging dynamic form of public utility regulation. Okay, let's go to the first one, market structure. Really, the EU rule book, and that's even not the DMA and the DSA, but it's an old e-commerce directive of 2000, which clearly try to minimize as much as possible the entry barrier for a new platform to arrive on the European market. So basically, what the e-commerce directive is saying is 2 things. Is first, if your platform is established in one of the member states of the European Union, it can provide its services to all the rest of the European Union without any more condition. So that's why, for instance, Meta is established in Ireland for probably tax and privacy reasons, but then Meta can provide its services all over the European Union without additional regulation. Okay, Amazon is established in Luxembourg for, again, tax and probably privacy reason, and then they can provide the services all over the European Union. So basically, you could see that there we are clearly in the same logic of reducing as much as possible the regulatory entry barriers. Second, access and common carriage. So remember, in the dynamic toolkit or dynamic framework, the access obligation are at the wholesale level, not the retail level. That's exactly what you find in the DMA with all those access and interoperability obligations, which make Apple so mad. That's about that, that's about forcing Apple to interoperate with a new app more easily, or a new app store, or a new wearable for their ecosystem, But of course, there is some exception, and in the DMA, you could see that there are 3 main exceptions if the interoperability poses problems for service integrity, privacy, and security. The gatekeeper can say no. Okay, but so you could see that there is a number of wholesale common carriage obligations in the DMA. Now, the most delicate one is universal service. Now, remember, universal service is the right to have access to a service at a price which is affordable. Now, you could say in digital, we don't care because very often all those services are free. So what is an affordable price in digital? But you know also that if a product is free, it means that you are the product, okay? So that you pay, in fact, not with money, but you pay with data, okay? And so basically what is interesting, if you read some of the provision of the DMA and some of the provision of the DSA, is that now, in some case, the platform have to offer you a service where you are not profiled. And that is what making Meta, in this case, so mad in the DMA, is that the Commission is forcing now Meta to come with an option which is still free, but where you don't receive online profile advertisement, but only contextual advertisement. Okay. And you have also another provision in the TSA, which gives you the right to be non-profiled on recommended system. So basically, I would say that the contemporary form of, or the modern form of a universal service is the right not to be profiled. But okay, you have some element of it in the DMA and the DSA. It's not a right as such, but I think you can see this new form of universal service emerging through the DMA and the DSA. And finally, in terms of risk prevention, there I think it's more the DSA doing stuff, but in terms of individual risk, as I was telling you, the DSA is providing an enhanced consumer protection, in particular against dark pattern. And then in terms of the collective risk, as I was telling you, the DSA is imposing a number of systemic risk assessment for the very large online platform. So basically, my point, and I will finish with this, you may know this famous play of Molière, Le Bourgeois Gentilhomme, where you have this guy who is a bit un nouveau riche, as we say now, new rich, who like to do big thing and so on. And then he has this person who said, that he was speaking prose, but speaking prose means speaking normally. And the Bourgeois Gentilhomme thing, it was a big thing, and he said, okay, I did that for 40 years without knowing it. He was so proud of himself by doing that. Now, my point is that to some extent, the European institution, and here it is Thierry Breton, who was one of the main architects of the DSA and the DMA, was doing public utility regulation without knowing it. Because I really insist, I don't think the DSA and the DMA have been seen politically as a public utility regulation, but I think we can read them as public utility regulation. Now, the question is, you can to me, so what? Because I had, I present this thing in my name 1 month ago, and I had my old advisor, Massimo Motta, who was listening very nicely to my presentation, and he told me, yes, but so what? But what I think means that we are putting those platforms in another conception, in another understanding that they are public utilities, and therefore they should be seen like that, regulated like that. Now, to be clear, this is contested. There is some paper, Christopher Yu, for instance, from Penn University, who is a very specialist of those questions, think it will be crazy to see platform as public utilities, because it has this narrow economic view of what is a public utility. But I think if you have the broad Brandeisian view, I think it makes total sense to see them as public utilities and regulate them as such. Now, that means what? That means that we have a kind of a trajectory for what we want to do with platform. That means that we have a trajectory which is not new, so that we can learn from past public utility regulation, and that for new issue like AI that everyone is discussing now, I think the trajectory on which the platform have been set up now in Europe, which is openness for innovation and better governance to decrease, better internal governance to decrease the risk, those two, let's say, leg of the EU digital rule could be applied, and I would say should be applied to AI services too. Thank you very much.
We could go on and on, but so we have to move on. Thank you all for attending, and thank you, Alex, again for a really wonderful, brilliant talk. Thank you very much.
Very much. Thanks to you.